Okay, we are now streaming, and welcome all. I think maybe there was another. Okay, well, I'm just going to have to wing this a little bit. Welcome everybody. I think we've started the live stream, so if you are a participant, I think now is probably the time that we ask you all to join us and come in and turn your cameras on and all those things. And thank you and welcome on Saturday afternoon. Good afternoon to all of you. I see a lot of faces, and that's terrific. Welcome all, and bear with me as I stumble through the judging aspect of this, but I'll get the judging part, I think, pretty well, but the tech and the adjustments a little bit new to me. So welcome to all of you. Let's see. So pretrial issues, I'll kind of run through these, and the team leaders can jump in, or maybe the others online if they think I'm misstepping. But I have here on this page that kind of what we follow. I guess the first check is to make sure the scoring panelists check and see that there's no conflict. If they recognize anybody, and I'll do the same. I don't expect that I would, and I don't. So good afternoon to all of you. I don't see any indication from our scoring panelists of any concerns. Okay. All right, thank you. Now, prior to starting preliminary trial matters, I am to wait for an okay from the state coordinator on the courtroom monitor. So maybe I already have that okay by virtue of him starting the webcast. Let's say that
I believe so, Your Honor.
Okay, thank you. Okay, thank you. So I think at this point, the court will administer oaths to the gallery, the volunteer, and the team oaths. Which I don't see in front of me. So we'll just, I'll just administer a general oath. I think the people who are participating and just observing, I don't know what oath I would necessarily give to them. But I guess if any of you are out there, if you would all please promise and affirm that you will observe the matter, not interfere with the matter, and remember that it's a competition, but yet meant to be fun and educational. So thank you to those of you in the gallery. As to the volunteers, I know these attorneys, some from working with them here in the courtroom as well. Do both of you solemnly swear and affirm that you will score these participants fairly and to the utmost of your ability, and likewise in a fun and educational manner?
I do.
Yes, Your Honor.
Great, thank you. And now to the participants, we'll swear in all the witnesses at this time. If you would each of the witnesses, please raise your right hand. Do you each solemnly swear or affirm that you will stick to the scripts fairly and according to the rules of the game, and that the characters will be testifying truthfully to the best of their ability, or at least consistently with the rules of the game? Okay, all right, thank you. I see everybody nodding. All right, the oaths have been taken. I see that we have some timekeepers on, and the court would now open this up if there are any preliminary matters for the parties to address prior to beginning the trial. I think probably two. Let's start with the team names if you, oh, and I see numbers next to your names, which is smart. Thank you. You were going to address the court there. Ms. Thomas.
Yes, Your Honor, we have 5 preliminary matters to attend to. For each of them, we have the court's instruction on behalf of both the prosecution and the defense. If at any time the court cannot see or hear a lawyer who is speaking, a witness who is testifying, or an exhibit being displayed, we ask the court to interrupt so that problem can be resolved.
Okay. That sounds like a reasonable request. I will do so, and you all may do so if you cannot hear. And it's a little quiet for me hearing right now, but I am able to hear you.
If technical difficulties stop the trial for more than 20 to 30 seconds, we ask the court to direct the timers to stop until the trial can proceed.
Okay, any objection?
No, Your Honor.
All right. That's so ordered.
Under Competition Rule 7.4, a team may screen share an exhibit when seeking admission of the exhibit. The rule provides that a screen sharing exhibit will be deemed not to have been shown to the jury unless admitted into evidence. How would the court like the teams to proceed when seeking admissions of the exhibits?
Will you say that last part again? Again, it got kind of quiet on me, and I don't know if maybe I have a not great connection, but.
How would the court like the teams to proceed when seeking admission of an exhibit?
I think just you show it to the witness, offer it. I think it's appropriate and fine if you wish to share the exhibit. If I think I understand the question, if you wish to present the exhibit on the Zoom and show it that way, I think that is appropriate since that's our best manner to show a witness.
All right. Under Competition Rule 7.4 and 4.7, a team may use Zoom annotation features to mark exhibits electronically. Once an exhibit is admitted, would the court like us to ask permission before marking exhibit?
I don't think that's necessary.
All right. That's all. Thank you.
Okay, thank you. Any preliminary matters from the defense?
Yes, Your Honor. We request that timekeepers post the time in the public chat.
Any objection?
No, Your Honor.
Okay.
We also ask that any participants who are not currently presenting mute their microphones and their cameras.
That's a wise request. Any objection to that? Okay, the court will order that as well. And I mean, especially with the sound with the mute, because that could conceivably interrupt if somebody's accidentally live.
We also ask that both counsels and their witnesses introduce themselves before the trial starts.
Thank you. I knew I'd forgotten a step. Yes, that's a good idea, good plan. Thank you very much. So let's go ahead and take that step now. Thank you for that reminder. We could begin with the prosecution, if we would.
My name is Peyton McQuestion. Today I'll be giving the opening statement, directing Detective Jordan Markowitz, and I will be crossing Blake Van Owen.
Good afternoon.
My name is James Steele. I will be crossing Taylor Perkins, and I will also be giving the closing statement and directing Alex Fuentes.
Good afternoon.
I am Emma Espino, portraying the role of Alex Fuentes.
Good afternoon.
I'm Sailor Rule, and I'm portraying Detective Jordan Markowitz.
Good afternoon.
I am Taylor Gleim, and I will be playing Kyle Kuzak.
Good afternoon. Thank you. And for the defense?
Good morning, Your Honor, opposing counsel, members of the jury. My name is Ella Thomas, and I will be delivering the opening statement on behalf of the defense, conducting the direct examination of Taylor Perkins and the cross-examination of Kyle Kuzak.
Good
Morning.
afternoon.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Natalie Galgano, and today I will be conducting the direct examination of Avery Becker and the cross-examination of Alex Fuentes.
Good afternoon.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Kate Saringer, and I will be conducting the direct of Blake Van Owen, the cross of Jordan Markowitz, as well as conducting the closing statement on behalf of the defense.
Good afternoon.
At this time, may our witnesses please introduce themselves?
They may, as may the prosecution witnesses. And I guess in order to keep that same order, we'll go with the prosecution first. Thank you for that reminder. So the witnesses may introduce themselves. Begin with the prosecution.
Your Honor, I believe the prosecution witnesses have already introduced themselves.
Okay, thank you. Okay, yes, your witnesses may certainly introduce themselves as well.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Jacob Durso, and today I am Blake Van Owen.
Good afternoon.
Good morning, Your Honor. Members of the jury, my name is Darwin Ortiz Garcia, and I am Tyler Perkins.
Good afternoon.
Good afternoon, Your Honor, members of the jury. My name is Maren Damtu, and today I am Avery Becker.
Good afternoon. And welcome all. So it sounds like we've conducted the preliminary matters.
Excuse
I'd like to...
me, Your Honor. I'm
Sure.
sorry to interrupt. One of our teammates got accidentally kicked out due to Wi-Fi issues. Is it okay if we wait for her?
Yes.
Thank you, Your Honor.
While we wait, Team 7, if you have a roster, that would be really helpful, and you can drop it in the chat. If not, we can just make sure we're following along.
We have a link to one in the chat.
Thank you.
Okay, and you all can let me know when you have everyone back.
Your Honor, I've just talked to my fellow teammates and we've decided if it is okay with you to just continue with openings, and she should be in by the time she is going to direct her witness, just so we can get things going.
That sounds great. Thank you. Thank you for that accommodation. Yeah, in that case, when you're ready for the prosecution, you may begin opening.
Thank you, Your Honor. Ladies and gentlemen of the jury, opposing counsel, Your Honor, today we bring forth to you a case of murder. On March 6, 2020, Colorado high school teacher and mock trial coach Mr Brachman was killed in his private residence, having been stabbed in the back. Today you will be given two stories. The first, given by my counsel, is based on facts and logic only. The second is a narrative spun by two teenagers, with a storyline comparable to that of a ludicrous plot of a classic high school drama TV show. In our case, you will meet two experts, Detective Jordan Markowitz and Kyle Kuzak, a detective with specialized training in cell phone forensic recovery and a certified crime scene investigator, and Alex Fuentes, a former friend of the accused who cared more about justice than maintaining their social life. On the defense, you will meet a single expert paid to testify on the side of the defense with a biased investigation and report. This would be Blake Van Owen. He launched this investigation to contradict the work of the police with the goal of painting Avery Becker in an innocent light. You will also meet Avery Becker, accused of murdering Mackenzie Brachman, an impulsive and emotional teenager who acted out of anger, and Avery's best friend, Taylor Perkins, who is just fresh out of high school. Our job as the prosecution is to bring justice to this case, and I'm sure that me and my co-counsel will prove Avery Becker's guilt beyond a shadow of a doubt. The defense is here to protect a murderer. We're here to protect our community. We're on your side, ladies and gentlemen. We want to help you. And in order to do so, we need you to listen to the facts and the logic and to come to the decision that Avery Becker is in fact guilty of murdering Mackenzie Brachman, a decision that I ask you don't take lightly, as the safety of our community might be at stake. That is all, Your Honor.
Right. Thank you. Does the defense wish to present an opening statement as well?
Yes, Your Honor.
You may, when you're ready.
An easy conclusion. Ladies and gentlemen of the jury, today you're going to hear about the murder of high school mock trial coach Mackenzie Brachman. He was stabbed in the back at his own house by a masked intruder on March 6, 2020. This intruder was caught on video entering the house through the back door. Today, the prosecution is going to try to tell you that that masked intruder was the defendant, Avery Becker. But as you will see, the police and the prosecution have settled for the easy conclusion. Today, you are going to hear about the argument that Avery Becker and Coach Brachman got into a few days before his murder. The prosecution believes that this is enough motive for murder. However, the defense believes differently. In today's case, Avery Becker has been charged with second-degree burglary and felony murder. The prosecution has the burden of proof. It is their job to prove that Avery Becker committed these crimes beyond a reasonable doubt. To prove burglary, the prosecution has to prove that Avery Becker unlawfully entered Mackenzie Brachman's house with the intent to damage Coach Brachman's property. To prove felony murder, the prosecution has to prove that someone died while Avery Becker was committing that burglary. To convict Avery Becker, you must be convinced beyond a reasonable doubt that Avery Becker murdered her mock trial coach. But after you have seen all the evidence, you will see that there is a tremendous amount of doubt because the prosecution has settled for the easy conclusion. Ladies and gentlemen, the defense does not have the burden of proof and does not need to call any witnesses to the stand, but we will, in order to show to you how the prosecution has rushed to an easy conclusion. First, we will show you the investigation was sloppy and rushed. Detectives at the crime scene found no evidence linking Avery Becker to that crime scene. Not a hair, shoe print, fingerprint, or even one speck of DNA evidence. There are ring video recordings of the intruder entering the house. However, these recordings do not show any defining characteristics, such as hair color or skin color. Instead, it only shows a vague interpretation of height and build. But many people in the state of Colorado have a similar height and build as the person in these videos. This again shows that the prosecution has settled for the easy conclusion. Next, we will show you that there is someone else who could have committed this crime. The alternative suspect in this murder, Blair Rollins, was not thoroughly investigated. Mr. Rollins' father was put to jail and Coach Brachman was his lawyer. Mr. Rollins left the courtroom claiming he would get Brachman if it was the last thing he did. The defense believes that because Mr. Rollins is still in jail, that Blair Rollins, Mr. Rollins' son, has a clear motive to murder Coach Brachman. Blair Rollins also matches the general height and build in these ring videos, was not present at school the day of Coach Brachman's murder, and has mysteriously disappeared since the day of that murder. You will hear from Mr. Blake Van Owen, who is an expert in crime scene reconstruction and cell phone data analysis. He is one of our witnesses. Mr. Van Owens believes that this investigation was sloppy and rushed, and that Mr. Blair Rollins is a possible suspect in this crime. This is further reason to believe that the prosecution has settled for the easy conclusion. Finally, you will see that Avery Becker could not have possibly committed these crimes simply because Mrs. Becker has an alibi. The defendant sitting in front of you right now was with another person the entire day that Mr. Brachman was murdered. Mr. Taylor Perkins is one of our witnesses. He will testify that he was with Miss Becker the entire day of Mr. Brachman's murder. Miss Becker will also take the stand in her own defense and will testify that she was with Mr. Perkins all day on March 6, 2020. Today, we will show you that the prosecution has settled for an easy conclusion. And at the end of today's trial, my co-counsel, Kate Schneringer, will stand before you and ask you to return a verdict of not guilty. Thank you.
All right, thank you. First witness?
Yes, Your Honor. I would like to call Detective Jordan Markowitz to the stand.
You may, Detective Markowitz. Welcome. You may be seated. Looks like you're already seated, as we all are. And you've been previously sworn. So, counsel, you may begin with the inquiry when you're ready.
All right. State your name and spell it for the court.
Jordan Markowitz, JordanMarkowitz.
And what is your current career?
I'm a homicide detective with the Denver Police Department.
And how long have you been with the Denver Police Department?
I've worked here for 13 years and I've been a detective for 7.
And what are your areas of expertise?
I have specialized training with cell phones and forensic data recovery.
And what did you have to do to earn those certifications?
I had to pass a training course and a certification test.
Describe how you use that training as an expert.
I find the records that are obtained and how to use the forensic software to download the information from a cell phone and how to understand the cellular records from a cell tower.
Thank you. Your Honor, I would like to enter Detective Jordan Markowitz as an expert homicide detective with specialization in cell phone and forensic data recovery.
Any objection?
No, Your Honor.
She's authorized to testify as an expert in the cell phone data collection as requested.
Thank you, Your Honor. How are you related to this case?
I was assigned to the investigation of the case of Mackenzie Brachman, a criminal defense lawyer's death.
And can you give a brief description of the crime scene?
Yes, when I got there, I saw the victim in the front doorway of their home, deceased with a obvious stab wound. I also noticed a Ring doorbell along with a video camera on the back side of the home and a camera on the south side of the home.
And did the Ring doorbell serve any importance to this case?
Yes, it showed the build and height of the suspect.
Now, you mentioned that you're an expert in cell phone data recovery.
Yes.
How did that come into play during this case?
I was able to track what cell phone towers the suspect's phone had connected to during the day of the murder, and it showed a clear path from her house to the victim's home.
Were you able to do anything with the victim's cell phone?
Yes, I got it out of the crime scene, and I saw many emails and text messages concerning a club called Mock Trial, and so I contacted students from that club.
Any students specifically?
Avery Becker was one of them, and he was a past student, and Alex Fuentes I also contacted.
And what did Alex Fuentes tell you?
He told me that Avery had talked to him over text messages and had told him some very concerning things before the murder took place.
And did you investigate Becker further?
Yes, I did. It turned out that his phone had been tracked within the cell towers near the home at the time of the murder.
And did you get an interview with Becker?
I did.
You got an interview with Becker?
Can you repeat the question?
Did you get an interview with Avery Becker?
I don't recall.
All right. Did you manage to get a hold of Avery Becker's cell phone at all?
No.
Okay. Were you able to investigate anything in relation to Avery Becker's cell phone?
Yes, the text messages between him and Alex Fuentes that talked about him going and trashing Brachman's house, and talked about that he was going to, if he was upset about what he had done to the car, that what she had done to the car, wait until what happens to the house.
All right. Your Honor, permission to share my screen and show the witness what has been marked as exhibits 15 and 16?
You may.
Do you recognize this exhibit?
Yes, I do.
What is it?
It shows the cell towers that were picked up the cell phone calls that were in between Alex Fuentes and Avery Becker on the day of the murder. It clearly shows Avery Becker's home in the top triangle, and then a clear path down to Mr. Brachman's home.
And then, do you recognize this exhibit?
Yes.
Can you explain what that is?
Yes, it's showing the path that would have been taken by Becker.
All right. Your Honor, I would like to move to enter exhibits 15 and 16 into evidence and publish it to the jury.
Any objection?
No objection, Your Honor.
15 and 16 are admitted. You may publish.
And how is this evidence related to your case?
It clearly shows the path that would have been taken for Becker on the day of the murder. All the times would line up with the murder as well.
So, as an expert detective, what conclusion could you reasonably make given all this information?
I can come to the conclusion that Avery had come to the home and with the intentions to, quote, trash it, like she had texted Alex Fuentes, and it was a robbery gone bad, which sadly turned into a murder. And I believe that she didn't go with the intent to kill, but that is what sadly had to happen.
Thank you. No further questions, Your Honor.
Thank you. Cross-examination.
Yes. Let's start the investigation. You found a bloody knife in your investigation, correct?
Correct.
But on that knife, there were no fingerprints.
Correct.
None of Avery Becker's fingerprints.
Correct.
And there was no DNA in the house?
I believe that these questions are outside the scope of Ms. Markowitz's witness statement.
Go ahead.
Your Honor, they tendered Ms. Markowitz as an expert in homicide, as a homicide detective. So that is why I believe this is part of her knowledge.
But fingerprints were never mentioned in her witness statement, Your Honor.
Okay. The court would determine, yeah, I think we have to, of course, stick with the scripts, but it being a murder investigation, it's a fair point for the defense to point out that certain evidence which may not have been collected or received. And so in that manner, the court will overrule the objection, determining that if it's not listed in the detective's report, it's something that they didn't do or receive. So you may proceed.
Okay. When you were investigating the house, you couldn't find any DNA.
I didn't collect any DNA.
None of Avery Becker's DNA?
Correct.
And there were no eyewitnesses of this crime, correct?
Correct.
And you took some pictures of this crime scene, correct?
Yes.
But some of those pictures were of blood drops.
Yes.
And yet those pictures became corrupted.
I'm sorry, I don't feel comfortable speaking about something that we don't have in front of us in the court today.
Ms. Markowitz, in your witness statement, you said that these pictures became corrupted.
Yes.
Next, let's talk about the Ring doorbell videos. You did look at the Ring doorbell videos, didn't you?
Correct.
And the video showed a person breaking in Coach Brachman's home, correct?
Correct.
Permission to screen share Exhibit 12, Your Honor?
You may.
May my co-counsel please share Exhibit 12? Thank you. You recognize this video, correct, Ms. Markowitz?
Yes, correct.
And there's been no altercations to this evidence since you've last saw it, correct?
Correct.
At this time, Your Honor, I'd like to enter Exhibit 12 into evidence.
Any
Objection.
objection?
A lack of foundation. I believe that this lacks the predicate foundation for admissibility, and I would ask that opposing counsel ask more questions.
Okay. Further foundation may be established.
Ms. Markowitz, you reviewed these videos when doing this investigation, correct?
Yes.
And in these videos, the suspect, which you believe is Ms. Becker, is in these videos?
Correct.
At this time, I'd like to enter it into evidence, Your Honor.
No objections.
Okay. There being no further objection, the court will admit Exhibit 12.
In the video, you can't identify the gender of this person.
Correct.
You can't identify the race of this person.
Correct.
You can't even identify the age of this person.
That's correct.
Okay, thank you. You may take the video down. Let's move on to the screenshots you obtained from Alex Fuentes. You met Alex Fuentes when you were interviewing people for the mock trial team?
Assuming facts not yet entered into evidence.
Overruled. I mean, I think if it's within the case file and this being the lead detective, I'll allow some inquiry about the case generally.
Ms. Markowitz, you met Mr. Fuentes when you were interviewing for the mock trial, interviewing the mock trial team, correct?
Yes, correct.
And so you called her in to have a full interview, correct?
Yes, correct.
And you asked Mr. Fuentes to see her phone, isn't that right?
Yes. She didn't bring it with her.
But this was unusual to you.
I've just never seen a teenager without their phone, but that was all.
This might have been the only time you've ever seen a teenager who didn't have their phone on.
Relevance?
A response?
Your Honor, I'm just trying to prove the fact that Ms. Markowitz normally wasn't able to get the phone from Alex Fuentes because Alex Fuentes forgot her phone. But this was the only time that Ms. Markowitz had ever seen someone a teenager who didn't have their phone on them.
And why would that relative piece of information be relevant to the case?
This is relevant because Ms. Markowitz never got Alex Fuentes' phone.
The court would determine that it will overrule the objection as the question goes to the sufficiency of the investigation and whether other certain leads may or may not have ultimately either been followed or whether they suggest that they might have the wrong person, etc. So the court determines it's a relevant question and the objection is overruled.
So you just asked Mr. Fuentes to send you a screenshot.
Correct.
And you didn't have Mr. Fuentes bring in her phone at a later time?
That's correct.
You never saw Mr. Fuentes' phone.
That's correct.
So you were never able to...
Asked and answered. Opposing counsel has asked the same kind of question multiple times now.
Overruled. It was slightly different. Certainly, we're not going to allow cumulative evidence, but I don't think we're there just yet. But I understand the objection and agree that that's a valid premise for an objection, but on these present circumstances, overruled for now.
Thank you. You never were able to download the information on the phone?
Yes, that is correct.
So during your investigation, you reached out to see Ms. Becker's phone.
Yes.
But you learned she had lost it.
Yes.
And finally, let's move on to the cell phone towers. Most of the time, a cell phone tower connects to the nearest tower, correct?
Correct.
But if its nearest tower is busy, a cell phone might connect to a tower that is further away but less busy.
That is correct.
And a cell phone tower data is not like a GPS.
It's not an exact GPS.
So you don't know exactly where a person is?
Well, that's correct.
All you know if the person's phone is within the range of a cell phone tower.
Yes.
And Avery Becker's phone
showed the exact path that Avery would have taken to get to Brachman's house.
I'm not asking about the path. I'm just saying cell phone towers show a range.
Yes.
And Avery Becker's phone could have been connecting to a farther out tower.
It's possible.
No further questions, Your Honor.
And remind me whether there's redirect.
There is redirect, Your Honor.
Okay, and you may if you wish.
Again, you've been a homicide detective for 7 years, correct?
That's correct.
And it's your job to launch a thorough investigation on any case you are given.
Yes, I let the evidence lead me where I go.
And it's your job to investigate any leads you might be given.
Correct.
And Alex Fuentes gave you a big lead in the case.
Yes, it was my big break in the case.
So of course you investigated it.
Of course, yes.
No further questions, Your Honor.
Okay. Thank you. Detective, you may step down. And are there further witnesses for the prosecution?
Hello, Your Honor. I would really like to introduce myself since I was having internet issues at the beginning. My name is Juliette Buckley, and I am an prosecution attorney, and I'm crossing Avery Becker. And I'd like to call Kyle Kuzak to the stand, please.
You may. Thank you for introducing yourself and good afternoon. If the witness, let's see, where's our witness? Our witness has been previously sworn and you may be seated. When you're ready, counsel, you may begin your examination.
Please.
And Ms. Buckley, I'm not getting a great signal there, so I think we may have lost you again, unfortunately. we'll pause a moment here and hopefully we'll get her back.
Can you- Can you hear me now?
Yes, good afternoon. Welcome back. Thank you. Go ahead. You can start from the beginning, and the time should start here when you're ready.
Okay. Can you please state
Maybe if she tries turning off her video.
That's a good idea.
And one other option is she could call in to use phone audio instead of audio from her phone. So even if her video freezes, we can still hear her.
Also a good idea. So I don't know if either of those would work, Miss Buckley. Well, I'll say this much. This part is very much like everyday court because this always happens when we're doing stuff remotely as well. So it's just a new fact of life for the courts. So we'll pause and wait and hopefully figure out a workaround. So I'll leave it to the prosecution if you wish. You could, and it's acceptable to the defense. We could also consider whether you want to call somebody out of order. But I see Miss Buckley back, and maybe if she could give that a shot, and maybe without the video, if she wishes, she can try it that way. However you all would like to proceed there, Team 7.
Your Honor, she's reconnecting right now.
Okay.
Just got a message. Is everything okay? Do you need assistance with tech?
Yeah, so I mean, I think she's reconnecting now, but she may need some assistance. If it doesn't still work, she may need some steps to be able to connect through phone audio, similar to the instructions you gave this morning.
Sure. Who is the participant that needs the assistance?
Miss Buckley.
Okay.
Juliet Buckley, yeah.
I see Miss Buckley is still in the meeting with us. Was she going to try to reconnect?
She had tried a couple times. Let's see if we have her now. She's muted at the moment.
Yeah.
I promise, Your Honor, this would never happen on a real court.
Does all the time, though.
I was going to say, it happens more often than you want to realize.
Your Honor, if we may, we apologize for the inconvenience, but we could move on to the next witness while Ms. Buckley is trying to reconnect.
I think that sounds great. Yeah, let's go ahead and do that. If I imagine, yeah, let's go ahead and do that. Why don't you call your next witness? We can come back to this one.
Thank you, Your Honor. I would like to call Alex Fuentes to the stand, please.
Okay, you may. Good afternoon to our witness. You may be seated. You've been previously sworn in. Counsel, when you're ready, you may begin your examination.
Thank you, Your Honor. State your name and spell it for the court, please.
My name is Alex Fuentes. That would be ALEXSIFUENTS.
What high school did you go to, and are you going to?
I go to Colorado High School, and at the time, the murders would be the same high school.
Are you on the mock trial team?
I was.
Is Avery also on the mock trial team?
She was as well.
So you must have insight on what the relationship was like between Brachman and Avery, correct?
Oh my goodness. They were always at each other, if I'm being completely honest with you. Always bickering at each other due to Avery's lack of commitment.
I see. So Avery was not an active student?
Absolutely not.
What was your relationship like with Avery then?
I will say we were pretty good friends and really good teammates, and we always pushed each other to do better.
And it's my understanding that Avery vandalized Mr. Brachman's car from an altercation that they had from mock trial. Why would Becker do that?
I witnessed beforehand.
Lack of personal knowledge.
Your Honor, my witness here is very friends with the defendant and also has lots of insight on the relationship between Brachman, seeing that they're all in mock trial together.
I'll sustain as to foundation is it's unclear how the witness would know what the defendant was thinking at this point in time.
If I may, Your Honor, I'm about to end that question.
Okay, you may.
So I ask again, why would Avery vandalize Brachman's car?
I witnessed myself beforehand, Avery and Mr. Brachman again arguing, but this time it was a little bit different, and it seemed like one of those moments which you would describe as the final straw, and this is in which afterwards Avery went and vandalized Mr. Brachman's car.
I see. So this time was different.
Absolutely. It just seemed like she had had enough.
And what were the consequences of Avery's wrongdoing?
She got kicked off the mock trial team.
Did she ask you for help to get back on the mock trial team?
She did, actually.
And did you try and help her?
I did indeed.
How did she reach out to you?
She sent me a text message asking me for help, and then soon after that, it turned out Mr. Brachman was pretty affirmed that he was not gonna get her back on the team.
I see. Your Honor, permission to show my witness what has been marked as Exhibit 14?
You may.
Do you recognize this exhibit?
Yes, I do.
And what is it?
These are the text messages between me and Avery.
You explained that Avery asked you to get help to get back on the mock trial team. Can you read your fourth paragraph that you sent? That Avery sent, sorry.
Avery sent, quote, well, if he's still upset about his car, then he's going to be really upset when he sees what I did to his house.
Your Honor, I would like to enter Exhibit 14 into evidence as it shows Mr. Becker's motive to going to Brachman's house.
Any objection?
Yes, objection, authenticity.
Any argument in response?
A moment to confer with co-counsel, please.
You may.
Thank you. Your Honor, Exhibit 14 was used as a break in Detective Markowitz's case and was a key turning point in his case. So it's vital to understand and for me to publish to the jury what made him excel in his case.
Thank you. The court would determine as follows: the challenges as to the authenticity of the document, whether it is what the proponent purports it to be here. The critical issue is whether it's a text message between this witness and the defendant and is in fact that. The witness has testified accordingly. There's sufficient evidence in the court's determination to believe that it's what the proponent purports that it is. So the court will overrule the objection and admit Exhibit 14.
Thank you, Your Honor. Back to my questions. What was the last in-person contact you had with Ms. Becker?
The night before the murder.
Where were you?
Where was I on the day of the murder?
The day before the murder.
I was at the fry shack at some point at the end of the day.
And who was there?
Avery and Taylor Perkins.
Did Avery seem angry?
I remember her going to the bathroom, but nothing that I completely recall when it comes to emotion.
Do you know who Blair Rollins is?
I know of him, but I don't know him, if that makes sense.
That makes sense. Thank you. And finally, Avery Becker vandalized Mr. Brachman's car. Do you think seeing that you were so close to Miss Becker and Coach Brachman, do you think he's capable of vandalizing his home?
Absolutely. If she can vandalize a car, you really don't think she'd go and vandalize his house?
No further questions, Your Honor.
Objection. Never mind. Pass.
Okay. Was there an objection or would you like to begin cross-examination?
Well, the moment has passed, so it's okay.
Okay. That happens. Okay, cross-examination.
So, Ms. Fuentes, you know Avery Becker from school, correct?
Yes, correct.
And you were on mock trial with her, like you said.
Correct.
And you and her were friends.
Also correct.
But you worked hard at mock trial.
As we all did, yes.
And you put a considerable amount of time into your roles.
Yes.
And Avery would always show up unprepared and late.
That is also true.
And it was make the team anxious, and it angered you.
It annoyed us, definitely.
And it was irking how she could just be so naturally good at mock trial.
I mean, I suppose.
And she was eventually kicked off the A team and demoted to B.
That is also correct.
But that didn't last too long because she was eventually put back on A before regionals.
Yeah, because she was really good, and she had this thing where she was able to just lie on the spot and nobody else could fulfill that role on the A team, so they put her back on.
And this was upsetting to you.
I mean, of
Objection, Your Honor. What does her feelings about Avery Becker's position on the mock trial have to do with this case?
Any response?
Your Honor, this has to do with the case because it is establishing potential bias of the witness.
I agree. And the court will overrule the objection as the motive or bias of a witness's fair area of exploration on the cross-examination.
Can you repeat the question?
Ms. Fuentes, it was annoying that Avery got put back on the A team.
I suppose, yeah.
And you thought the A team was better off without her.
I mean, that's also true.
And you would have gotten a bigger role with Avery being off the A team.
That is absolutely correct.
So, moving on to the investigation. You claim that you got text messages from Avery shortly before Coach Brachman's murder.
Yes, which I will say were quite shocking.
Yes, and you claim that they were threatening towards Coach Brachman.
Absolutely.
But this was when the police called you, that was the first time they'd ever seen the messages.
Yes, I suppose that would be correct, yes.
And so you were asked to come down and interview about these messages.
Yes, I was. Or just to give in my statement as to what had happened or what was relevant to the case.
But the main reason they asked you to come down was for the text messages.
Yes.
And when you went down to the station, you did not bring your cell phone.
I did not. I accidentally left it charging.
Yes, but the phone was not with you when you went to the interview.
No, it's not, but they pre-approved that I could just, or they didn't pre-approve, but after I explained my situation, they just said I could send them in.
And because you didn't bring your phone, you were asked to send in screenshots like you had just said.
Which they approved.
Yes, and the detective never saw your physical phone.
No, but they saw the screenshots, which again were approved.
And the detective never saw the messages on the physical phone.
No, he did not.
Objection, Your Honor. Asked and answered. She keeps asking the same question if the detective had seen the physical phone or not.
Any response?
Your Honor, my first question was about the phone itself, and my second question was about the messages on the phone.
Similar to my last ruling, I agree that cumulative evidence can be distracting and is an appropriate objection. However, I think the questions are distinguished enough that I'll overrule the objection for now.
Later, Sorry.
Go ahead. Thank you.
Later, Ms. Fuentes, you were contacted by a private investigator.
Yeah, who was accusing me of forging the screenshots.
And you refused to talk to this investigator because you believe they were working for the defense.
Because the claims were outrageous. Like, why would I forge screenshots like that about one of my close friends?
Ms. Fuentes, that was not my question. My question was if you refused to talk to the investigator because you thought they were working for the defense.
Then I answered that it wasn't because of that reason. It was because their claims were outrageous.
And is that your statement here today in court?
Objection, Your Honor, badgering my witness.
Any response?
Your Honor, this is cross-examination. I am allowed to ask difficult questions.
I agree. I'll sustain this objection as I think turn the corner a little bit into from receiving information from the witness to sort of suggesting that the witness is wrong. So I'll sustain that objection. There's certainly tough questions are permitted, though.
Can you repeat the question, please?
That is your statement here today in court, that you refuse to talk to them because of their outrageous accusations.
In my affidavit, which is what I assume you're talking about, I do say in relevance that that I was quite upset about them accusing me of forging the screenshots.
Your Honor, could I have a moment to pull up her affidavit?
You may.
Permission to screen share her affidavit?
You may.
Now, Ms. Fuentes, is this your affidavit?
Yes, it is. May I direct you to the line in which I claim that I'm quite upset about being accused?
Can you give me 1 second?
Of course.
And this is your signature?
Yes, that is my signature.
Right here on line 92, it says, a couple of weeks ago, an investigator attempted to interview me. I mean, I'm on mock trial. I'm not stupid. I knew the private investigator was for the defense, which means she was just here to get a statement.
Objection, Your Honor. Relevance. This is about whether or not she was upset about a private investigator asking her about screenshots. I don't see how her feelings has to do with the murder of Mr. Brachman. I mean, this is about if she's upset about getting framed for screenshots.
Any response?
Your Honor, the witness refused to even speak to the investigator. Therefore, the investigator did not interview her at all. She also later learned from the investigator, not before refusing to speak to the investigator about the accusations. As it says down here, worse yet, I learned Avery accused me of stealing after the investigator had tried to talk to her.
The court will permit the questioning. It may pertain to the witness's credibility. It seems to the court that there's possibly exploring some prior inconsistent statements. That's a permissible use of a prior statement for credibility purposes. Also, the inquiry may explore the credibility of the witness or motive of the witness, and these questions may pertain to that too in terms of cooperating with one side but not the other. So the court determines it is a permissible line of inquiry and will overrule the objection.
And just lastly, you refused to talk to this investigator because who is someone who is trying to help your alleged friend. Is that a yes?
Weren't we still on the last question though?
My last question
about line 92.
My last question was, you refused to talk to the investigator because they were working for the defense.
My answer is no, because in that moment, since I had just been previously investigated by the police themselves, while still speaking to the person who was trying to question me, I found out that she was trying to accuse me of forging the screenshots, which made me even more persistent to not speak to her or cooperate with the private investigator.
So you refused to help an investigator that was trying to help your friend?
Yes, that is correct.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Permission to share my screen, or permission to show my witness what her affidavit.
You may.
Can you guys hear me?
Yes.
Yes.
Okay, my screen is weird. Might I direct your attention to line 99? May you please read out what line 99 says? Or actually start from 98.
98 after the period.
Yes.
She persisted in asking a few questions. That's how I learned I was basically being accused of the text messages from Avery. I mean, why would I create a fake text?
Can you please read on to the end of the paragraph?
Fake text exchange. I would never do such a thing. Like I said, not interested in the truth, just trying to way to get an equitable I'm so sorry, I can't read that word right now. To get an equitable even though the client is guilty.
So you would not fake screenshots,
Why would I do that?
and you're only interested in the truth.
Of course.
If might I also direct your attention to line 95. Can you please read what it says after testimony?
After testimony. If she was interested in the truth, I would have talked to her, but that's not the job of the defense.
So the reason why you did not want to talk to the defense attorney was because she was not interested in the truth, right?
Correct.
No further questions, Your Honor.
Okay, thank you. I thought there may have been an objection coming through, but I didn't quite hear it. Okay, didn't make it in time. All right, thank you. All right, thank you. The witness may step down. And are there further witnesses for the prosecution?
Hello, Your Honor. I'm back. I sincerely apologize for all of the internet issues.
There's no need to. It happens all the time. So we're glad we have you back. And did you wish to call the next witness?
Yes, I'd like to call Kyle Kuzak, please.
You may. And the witness may be seated. The witness is previously sworn, and when you're ready, counsel, you may begin your examination.
It's not working. Okay, wait. Can you guys hear me? Okay. Can you please state your name and spell it for the record, please?
My name is Kyle Kuzak, Kylekuzak.
And what do you currently do?
I am a Colorado Bureau of Investigation certified crime scene reconstructor investigator, also known as
Okay, and what do you specialize in?
investigating 3 complex crimes, domestic fatal accidents, and
Okay. How many years of experience do you have? Okay. Your Honor, I move to enter Kyle Kuzak as a Colorado Bureau of Investigation certified crime scene reconstruction investigator.
I'm sorry, Your Honor. I object on the stance that I cannot hear a word that that Kyle Kuzak is saying.
Okay.
I wasn't hearing there at the end of the witness either, so I was kind of waiting to see what I was able to hear.
Your Honor, do you want me to repeat the questions?
Sure, you may repeat the last few questions, if you don't mind.
Okay. Ms. Kuzak, can you hear me?
yeah, I can hear you. Can you guys hear me?
It sounds a bit better now.
Okay.
Okay, so what do you specialize in?
Investigating 3 complex crime scenes, including home invasions, burglaries, and other property crimes, 4 homicides, guns, fatal accidents, and armed robberies.
Okay, and how many years of experience do you have?
Years.
Yeah, and it's cutting out again, unfortunately.
Your Honor, if it's any help,
turn off my video.
And Ms. Thomas, we can't hear you either. Ms. Buckley, we can hear you, but Taylor, we're having issues with your feed as well. So the issue is not the questioning, the issue is the answers.
Would it help if we all turned our cameras off?
That's possible. We could try that.
Okay, may I proceed, Your Honor?
You may. Thank you.
Okay. Ms. Kuzak, would you like me to repeat the question?
Yes, please.
Okay. How many years of experience do you have?
19 years of experience.
Okay. Your Honor, I move to enter Kyle Kuzak as a Colorado Bureau of Investigation Certified Crime Scene Reconstruction Investigator.
Any objection?
No, Your Honor.
The witness is authorized to testify as an expert in crime scene reconstruction.
Okay, thank you. Are you employed anywhere else?
I'm a civilian employee of the Denver Police Department.
Okay. And moving on from that question, did you ever visit the crime scene of this case?
Yes.
When was that?
After it was processed by other members of the crime lab.
Okay. Can you describe what you did at this particular scene?
After it was processed by other members, I reviewed the crime scene, so all the police reports, all photographs, and the 4-ring security videos.
Okay. And what is the first thing you do in CSR?
Well, the essence of CSR works involves identification of event segments and their sequencing when possible, based on scientific principles and the scientific method.
And what was your method in this case?
I followed Tom Bevel and Ross Gardner's 7-step methodology for event analysis, including flowcharts for charting sequences and worksheets for applying the scientific method to difficult sequences.
Can you walk us through some of the key principles that guide your work in this case?
The 5 parts I do are recognition, documentation, collection of evidence, evaluation of evidence, hypothesis and testing, reconstruction. I first assume that every case is going to trial, so I conduct a thorough, comprehensive investigation accordingly.
And can you explain to us the first step in this particular investigation?
First, I use a witness tracking spreadsheet to summarize the key points information of witnesses and suspects.
Okay. Your Honor, permission to share my screen and share what's been marked as Exhibit 17.
You may.
Do you recognize this document?
Yes.
And how does it relate to the case?
Evidence, it's ID numbers, the flow chart that I made.
Okay. Your Honor, I move to enter Exhibit 17 and constructively publish it to the jury.
Any objection?
No, Your Honor.
17 is admitted. You may publish.
Okay. Moving on. What were the next steps in your investigation?
I drew a flowchart and a timeline initially to maintain a macro perspective on information in this case to show key physical and chronological relationships. My second and third step is to prepare materials for formal analysis. In these, I expand the organizational framework for information, evidence, and images to document evidentiary relationships, lab submissions, and analysis.
And to prepare for your analysis, were you able to see all images available?
Yeah. The focus of in-depth analysis, I find separate spreadsheets are helpful.
Can you explain what you saw in these photographs?
The photographs in this case show small droplets of blood between the kitchen and the front door, where the knife and large pools of blood are located. Also showed blood cast off the wall and ceiling near the front door.
Now, it's my understanding that the blood cast off images were corrupted.
That is correct.
Okay. Now, what happened to the digital files? So, yeah.
They were partially corrupted in the photos and the photographs and cast off were lost at some point after my review.
Okay. Do you know about how much longer after?
Long after.
Okay. Moving on, what was your fourth step in this investigation?
Once the evidence was organized, I formally conducted a hypothesis and came up with an analysis.
During this process, was there anything else that you did?
I made observations of evidentiary relationships during the organization process.
Okay. Now, what was about the last thing you did during this process?
Well, the CSR case management process involves CSR initial report preparation, peer review, and final reconstruction report.
Okay. Your Honor, permission to share my screen and share what has been marked as Exhibit 10 with the witness?
You may.
Ms. Kuzak, do you recognize this exhibit?
Yes.
Okay. Your Honor, I move to enter Exhibit 10 and constructively publish it to the jury.
Any objection?
Yes, Your Honor, lack of foundation.
You may establish further foundation.
Counsel, this is helping prove the expertise level of Ms. Kuzak and how far her investigation went.
Okay.
Um,
Thank you. And maybe another question of the witness or two regarding the exhibit and what it is.
Ms. Kuzak, how did you figure out the maybe physical features of the witness?
Did we lose? Maybe we lost a connection.
Ms. Kuzak, are you able to hear us?
No. Can you guys hear me?
Well, now we can hear you.
Okay.
Would you like me to repeat my question?
Yes, please.
How are you able to find out the physical aspects and features of the defendant?
I was able to look at these videos and examine the suspect, and it looked like the same height and same build as Avery.
Okay.
Time.
Okay.
Okay.
All right. Thank you. Cross-examination.
Yes, Your Honor.
Good morning, Ms. Kuzak. Thank you for being here today. We're going to step right into it, starting with the murder weapon. You found a bloody knife at the crime scene, didn't you?
Yes.
And you believe that the murder weapon is this bloody knife?
Yes.
And you believe that the murder weapon belonged to Brachman?
Yes.
But are you aware that the bloody knife was a Chicago cutlery knife?
I don't recall.
Are you aware that the knife that has been used to murder Mr. Brachman is a Chicago cutlery knife?
Yes.
And yet the knives in the kitchen block in Mr. Brachman's house belong to a J.A. Henkel's knife set?
I do not recall.
All right. Well, the knives in the knife block belong to a J.A. Henkel's knife set.
Objection. What is the relevance of this question?
Your Honor, this is relevant to the fact that the murder weapon does not match the current knives that are in Mr. Brachman's home, therefore showing some gaps in the prosecution's theory.
Your Honor, may I respond?
You may.
I'm just a little confused about how this kind of relates to what the expert is saying or what they said prior.
Well, Your Honor, Kyle Kuzak testified in her witness statement that the bloody knife, was a Chicago cutlery, and yet the others were a J.A. Henkel's, which shows that they're not the same brand, and therefore that there's a possibility that someone could have brought a knife from outside of the house.
The court determines the circumstances and which weapon is used, where it came from, are fair areas of exploration for inquiry. So overruled.
Ms. Kuzak, is it possible that the murderer could have brought their own knife to Mr. Brachman's home?
Yes, it is possible.
In your observation, you also noted scuff marks on the floor, correct?
Yes, that is correct.
And you noted that the scuff marks indicated a struggle between the killer and the victim?
That is correct.
But couldn't these scuff marks have occurred any time before the murder?
Possibly.
All right. So there were no proof that the scuff marks were caused by the struggle?
No.
So you simply assume the marks were caused by the struggle?
Yes.
You also didn't find Avery Becker's fingerprints at the crime scene, correct?
That is correct.
Did you find her shoe prints?
I do not recall.
Did you find any DNA?
No.
So there is no physical evidence linking Avery Becker to Mr. Brachman's home?
No.
There are also no eyewitnesses, correct?
That is correct.
And you reviewed the ring videos?
Yes, I did.
So therefore you saw what the intruder was wearing?
Yes.
And you can determine from those ring videos the general height and general weight of the person who entered Mr. Brachman's house?
That is correct.
But you cannot clearly state the exact height and weight as the person in these videos, correct?
That is correct.
And the general height and weight also matches Blair Rollins, is that correct?
That is correct.
No more questions, Your Honor.
Any redirect? I'm not sure. Is there any redirect?
There's no time for redirect. They used all their time on their direct.
Okay. Further witnesses for the prosecution?
No, Your Honor.
All right. Are there witnesses for the defense?
We would like to call Blake Van Owen to the stand.
You may. The witness has been previously sworn and you may be seated. Counsel, when you're ready, you may begin your examination.
Could you introduce yourself to the jury?
My name is Blake Van Owen.
What's your current occupation?
I'm a private investigator, a consultant, and a professor at CU Denver.
Before that, did you have any other jobs?
Yes, I served as a police officer in the Aurora Police Department.
Did you attend college?
Yes, I attended Ashford University and I obtained a master's degree in criminal justice.
You said you've been a consultant. How many times have you been a consultant?
I've consulted in over 100 cases.
In what areas have you consulted in?
Various ones: police practices, use of force, false arrest, crime scene reconstruction, and cell phone tower analysis.
Have you testified before?
Yes, I have testified numerous times in court.
In what areas have you testified in?
I have testified as an expert in police practices 12 times, crime scene reconstruction 8 times, and cell phone tower analysis 5 times.
I would now like to tender Blake Van Owen as an expert in crime scene reconstruction, cell tower analysis, and general police investigation.
Any objection?
Yes, Your Honor. I would like to voir dire the witness.
You may.
Hello, Mr. Van Owen. Do you have any special training in crime scene reconstruction?
No, but I am self-taught as a consultant.
But you didn't go to classes or take any tests for that?
No.
Do you have any special training with cell phone data recovery?
No, but once again, my investigations in various other cases and consulting has included
But no formal training for either of those?
No certified official teaching, no.
Your Honor, I object to Blake Van Owen being entered as an expert in these areas.
May I respond?
You may.
My witness has just testified that he has a master's in criminal justice, and he's also been a consultant in over 100 cases. Under Rule 702, in order for a witness to be an expert, they need education and experience, and my witness has both.
Yes, Your Honor, but I don't believe this witness has any formal education in either of those subject areas.
All right. Well, the rule does require some form of expertise and some reason for expertise. It can be by education, training, or experience. The court determines that the threshold has been met, so we'll overrule the objection. The defense has, or the prosecution has pointed out some matters that pertain to experience, and that may go to the weight of the evidence and be considered by the jury for that purpose.
And what was your role in this case?
I've been hired by the defense to review the police investigation.
Did you reach any conclusions?
Yes, I have concluded that the police department has completely rushed this investigation.
Objection, speculation.
Overruled.
Could you elaborate?
There are 3 areas of the investigation that I am particularly concerned with.
What's your first area of concern?
First, the cell tower records cannot definitively place the defendant's phone at the scene of the crime, let alone the defendant herself.
What is your second area of concern?
Secondly, there are several pieces of evidence that have been carelessly omitted from this investigation.
And what is your third area of concern?
Lastly, the police failed to investigate a crucial suspect with a clear motive to murder the victim.
Let's begin talking about the cell phone records. What conclusions did you reach about the cell phone records?
There is no way to prove Becker's location just based off of the cell tower data.
How did you reach this conclusion?
Objection, narrative. This question calls for a narrative answer.
Any response?
Your Honor, my witness is an expert in cell phones, and he can give a conclusion on this certain topic.
He may describe how he reached the findings that he made. The court will overrule the present objection.
Would you like me to repeat the question, Mr. Van Owen?
Yes.
How did you reach your conclusion?
Looking through the various cell tower records, you can determine that the defendant could be at a maximum of 6 miles away from the victim's house. Using basic logic, apparently beyond that of the police department, you can determine that the defendant's phone being at a location does not mean the defendant was at said location.
Your Honor, Exhibit 15 has already been admitted into evidence. Permission to screen share Exhibit 15?
You may.
May my co-counsel please screen share Exhibit 15? Why are the cell phone records not enough to justify Avery's location?
There are 2 reasons for this.
What is your first reason?
Firstly, all I know is that the cell phone records show that Avery Becker's phone connected to a cell tower within the vicinity of Brachman's home. Cell phones typically connect when they are within a range of that tower, a range as large as 6 miles. However, cell towers cannot be used as a GPS. Cell phones don't always connect to the closest tower, rather to the one with the strongest signal.
And what is your second reason?
Secondly, even if the cell tower data places the defendant's phone at the scene of the crime, this doesn't prove that the defendant herself was at the scene of the crime. Further doubt comes into play with the knowledge that Avery Becker lost her phone on the day of the murder.
Did the cell phone records cover over a certain area of time?
Yes, the investigation subpoenaed a limited amount of time in relation to the cell phone records.
Okay, thank you, Ms. Javis. You can take down the document. Let's move on to the police investigation. Did the police examine any of the individual cell phones?
No, they simply accepted easily doctorable screenshots from Alex Fuentes and used data from cell towers that, of course, cannot be used as a GPS.
Next, let's talk about the crime scene reconstruction. Did you reach any conclusions?
The police's investigation was extremely rushed. Various pieces of evidence were left out of this case. They came to the easy conclusion, but not necessarily the correct one.
Why do you think the police investigation was rushed?
There are 2 reasons as to why I believe the police's investigation was rushed.
What is the first reason?
When observing the crime scene, we can see that photos of several blood spatters around the victim's home were missing.
Why do you believe this?
I have thoroughly examined Detective Markowitz's investigation of the crime scene.
What is the second reason?
The police investigation failed to obtain Alex Fuentes' cell phone, or anyone's cell phone within a 6-mile radius of the victim's home for that matter.
Why didn't they obtain Alex Fuentes' phone?
Objection, speculation.
Sustained.
Let's move on to the alternative suspect. Did you reach any conclusions?
Yes, the police investigation completely failed to investigate a crucial suspect that had a more potent and personal.
Objection, relevance. How
Your
would
Honor, if I could respond.
Relevant in the case of Avery Becker specifically?
You may respond.
Your Honor, we're trying to show that there was an alternative suspect that the police did not investigate.
That is an area that may be explored, overruled.
Did you reach any conclusions into the investigation of another suspect?
Yes, the police investigation completely failed to investigate a crucial suspect that had a more potent and personal motive to kill the victim than the defendant herself.
Who was this suspect?
He was a former CHS student named Blair Rollins.
What methods did you use to find him?
I conducted both a search through past CHS yearbooks and did some basic internet investigation.
Did you find any evidence that supports the motive to an alternative suspect?
Yes, I obtained an electronic recording from a court proceeding. Jonathan Rollins, who is Blair Rollins' father, was on trial for murder, and Mr Brachman was his attorney.
Do you know what happened in this trial?
Yes, I listened to the court recording.
Objection, narrative. This question calls for a narrative answer, Your Honor.
Any response?
Your Honor, I'm just laying foundation that my witness has listened to the court recording, and then we're going to enter evidence to show what was in the recording.
Your Honor, that doesn't prevent it from being a narrative answer.
The court will overrule the objection. It is a broad question, certainly, but it is a question seeking particular information, and so I'll overrule the narrative objection.
Was Blair Rollins present at his father's trial?
Yes, Blair Rollins was present, further amplifying his motive. In another court recording, Blair spoke on his father's behalf.
Is this recording accurate?
Yes.
Your Honor, at this time, I'd like to enter Exhibit 22 into evidence.
Any objection?
Yes, Your Honor. We don't even know what this exhibit is.
Your Honor.
Go ahead.
We're going to play the evidence after we admit it into evidence.
Your Honor, we still don't have a clear understanding of what this evidence is.
If I may make an offer of proof.
You may.
In the court recording, Jonathan Rollins says to Mr. Brachman, "I will get you back if it's the last thing that I do."
Okay. So I see it here within the case file. Can you, I see it's within the case file. Can you tell me more about the objection?
Your Honor, usually it is custom to show the evidence before entering it. At least show the evidence to the witness before entering it.
Okay. The court determines that the foundation has been made. The witness has identified the exhibit, although we haven't played it yet or had the witness listen to it independently here. He has identified it as an accurate recording of what he's purporting it to be. So the court will overrule the objection and admit Exhibit 22.
Can my co-counsel please play this audio clip?
Yes.
May my co-counsel please play this audio clip?
I'll get you back, Becker, if it's the last thing I do.
Thank you. Let's move on. Is there any other reason why you believe that Blair Rollins is a possible suspect?
Blair Rollins matches the height and build of the intruder in the Ring doorbell video.
Is Blair Rollins in Colorado anymore?
No, using some basic internet investigation techniques, I determined that Blair Rollins has fled the state of Colorado.
Do you think Blair Rollins should have been a suspect for this case?
Yes, it is my conclusion that Blair Rollins certainly...
Objection, improper character evidence. Character evidence cannot be used to prove the actions of a character or individual.
Response?
Your Honor, my witness is an expert in police investigation, and we're not saying that Blair Rollins did it. We're just saying he should have been a suspect for this case.
I'm persuaded by the distinction that the witness may testify about the investigation and has sufficient expertise to testify about steps that may have been taken. It would not be permissible for him to draw a conclusion, which is what we're asking the jury to do, but this present question is permissible. So overruled.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Why do you no longer work for the Aurora Police Department?
Well, I had a very saddening incident.
Can you elaborate on that?
Objection. Relevant.
Any response?
Your Honor, I'm just trying to lay foundation for the history of this character's expertise.
The court determines it's a permissible question. It could also, it appears to explore the motive of the witness as well. So in that regard, it's a permissible question. Overruled.
Okay, can you elaborate on that incident?
Due to practices I was instructed to use by the Aurora Police Department, I disappointingly injured a woman of color in my time on the force.
And that caused you to quit?
Yes.
And are you getting paid to be here today?
Objection. Relevant.
Your Honor, I'm just trying to locate any biases that may be present within this witness.
I'm persuaded by that argument. Exploring potential bias of a witness is permissible. The objection's overruled.
Again, I ask, are you getting paid to be here today?
Yes, but you have to make a living somehow.
But you are getting paid.
Yes.
And what side do you usually find yourself testifying for in these instances?
Usually for the defense.
And why is that?
Because I became extremely disillusioned.
Objection. Relevant.
Your Honor, again, I'm just trying to find any biases within this witness.
The objection's overruled. The potential biases may be explored.
Again, why do you find yourself testifying for the defense?
Because I've become extremely disillusioned with both police and prosecution practices.
So you see yourself as someone who puts the police in check?
I suppose so, in a way.
And you've had experiences with both Kyle Kuzak and Jordan Markowitz outside of this individual case?
Yes.
And you described Kyle Kuzak as egotistical after meeting him once at a conference?
Yes.
Would it have been possible for you to obtain records to verify your assumptions about the prosecution's investigation of cell phone towers?
Yes, but I don't have the burden of proof here today, do I?
No, you do not. But you still did not get any of the evidence to back up any of your claims.
I did not.
And did you visit the scene?
No. Or
You did not visit the scene.
no, I do not believe so.
And you were hired for Avery Becker to find any flaws in the police's investigation?
Yes, I was hired by the defense.
To find flaws in the police's investigation?
Objection. Relevant.
Your Honor, again, I'm just trying to find any biases that might be present within the witness.
Overruled. You may.
So your report is to identify any issues with the police's investigation, correct?
Yes, which I absolutely did find.
Okay, no further questions, Your Honor.
Any redirect?
Yes, Your Honor.
You may.
So, Mr. Van Owen, you were a cop in your past experience, correct?
Yes, I was.
And that gave you experience, correct?
Yes.
No further questions.
Okay, thank you. The witness may step down. Are there further witnesses for the defense?
There are, Your Honor. I just don't know what's happening with them right now.
Okay, We'll
Hold
take a moment. You can let us know when the appropriate person is ready for the next witness.
The defense calls Taylor Perkins to the stand, please.
You may. The witness has been previously sworn and may be seated, probably already seated, as we've noted. Counsel, when you're ready, you may begin.
Please introduce yourself to the jury.
My name is Tyler Perkins.
And what do you do?
I am a freshman at CU Boulder and currently studying software engineering.
Were you part of any activities while you were in high school?
Yes, I was a part of mock trial.
And do you know Avery Becker?
Yes, I know Avery Becker. We are best friends.
Moving on to talk about the CHS mock trial team, when did you and Avery join the team?
Avery and I joined our freshman year of high school.
And what was mock trial like?
I really didn't like mock trial much. I felt like it was a waste of time and I didn't take it seriously.
From what you've noticed, did any of your teammates come unprepared or late to practice?
Avery came late and unprepared to practices, but she did have a talent for mock trial, even unprepared.
What was your relationship with Coach Brachman like?
I thought the coach was mediocre. He often made bad choices for the team, and you know what they say, those who can do, and those who can't, coach.
Based on your observations, were you able to watch Coach Brachman and Avery interact?
Yes, I saw them interact many times.
And based on your observations, what was their relationship like?
You could say the relationship was rocky because Brachman would get mad and yell at Avery for coming unprepared and late to practice.
You were at the practice when Avery got demoted, but didn't see Coach Brachman's demotion, correct?
Yes. Coach Brachman was angry with Avery because she came too late unprepared, and this made the coach mad, so he decided to demote Avery to the B team.
Your Honor, lack of personal knowledge. I believe that Mr. Perkins was not at the altercation when Coach Brachman was talking to the defendant.
May I respond, Your Honor?
You may.
Taylor Perkins was present the day of the demotion, but did not see the actual demotion. So therefore, he can testify as he has done.
Your Honor, Taylor Perkins did not himself see the demotion, as stated.
Okay. The witness may testify to things that the witness actually observed. So to that extent, sustained. If we're going beyond that to things that the witness heard from another, that is an appropriate objection. So the witness may testify to the things the witness observed.
Mr. Perkins, what happened as a result of the demotion?
As a result, I stepped down from the mock trial team.
And was there any particular reason why you quit the team?
There were many factors to why I stepped down. Mock trial meant more to Avery than me. And besides, I wanted to support her as a friend. Avery had worked hard for the past 4 years, so I wanted to support her that way. And I didn't want to be on mock trial without a friend. And I felt like mock trial didn't mean anything to me anymore.
After regionals, did Avery attempt to get back on the team?
Yes, Avery and I talked about every way she could join the team once again.
And what did Avery do to attempt to get back on the team?
Avery was very sorry to Brachman and she tried everything to get back on the team.
Moving on to March 5th, do you recall that day?
Yes, I recall March 5th.
What did you do that day?
Avery swung by my house and we played games on our phones.
Did you go anywhere?
We went to the Fry Shack first and then the mall to do some shopping.
And who else was at the Fry Shack?
Alex and most of the mock trial team members showed up a few minutes later.
What happened while you were there?
There was a little smoke. Alex and Avery got into an argument.
And what did Avery do about this?
Avery stormed away to the bathrooms.
Did anyone leave anything?
I think that Avery left her phone on the table. It was so shocking because it was like a third kidney to her. And like most teenagers, they would never be apart from it for long.
Did you realize at the time that Avery did not have her phone?
At the time, I did not realize the phone was missing until the very next day.
Speaking of the next day, let's move on to March 6th. What did you do that day?
Since classes were going to be dry and boring, we decided to ditch.
Was there any particular reason why you ditched school?
We were going to look for Avery's missing phone.
And where did you go?
We retraced our steps to find the missing phone.
What methods did you use to try to find this phone?
We called and texted the phone various times to see if we could hear the tone.
And where exactly did you go?
We went to the mall and looked in every store, and then we went to the Fry Shack.
Were you and Avery together the entire time?
Yes, me and Avery were together the whole time, at the Fry Shack and at the mall.
So you were the only person with Avery the day of Coach Brachman's murder?
Yes, I was the only person with Avery at the day of Brachman's murder, but mall employees can verify we visited their stores to look for the missing phone.
Thank you. No more questions, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. And also do I have 4 minutes and 51 seconds? Or might I ask how long do I have for cross?
You have 16 minutes and 33 seconds.
Thank you. May I begin?
You may.
Let's see. What is your relationship to Avery Becker?
Avery and I are best friends. We were friends since elementary school.
I see. And you testified that you were on the mock trial team with Avery?
Yes, me and Avery were on the A team in mock trial.
And you also said that the relationship between the two was very bad. And by the two, I mean the defendant and Coach Brachman.
It was rocky at some times because Avery would come on late and prepared, and this made Brachman angry. I'm sorry, can you repeat the question?
Yes. You also testified that you went to the Fry Shack the day before the murder. Is that correct?
Yes, me and Avery went to get a snack because we were hungry after playing on our phones. I'm sorry, can you repeat the question?
Yeah, we're losing some sound a little bit here, so.
Can you hear me now?
Yes.
Okay. I'll repeat my question. You testified that you were at the Fry Shack the day before the murder. Is this correct?
Now we're hearing the question, but not the answer.
Yeah.
Goodness.
Can you repeat your answer?
Can you hear me?
Yes.
We went to the Fry Shack to get a snack because we were hungry and we had decided after we had finished playing games on our phones.
I see. And you said that Avery seemed angry, correct?
When did I say that?
When you were talking to the defense attorney, Ms. Thomas, you said that Avery was angry and stormed off to the bathroom.
Yes, she was angry. She wasn't angry. She was sad because of an incident that happened at the Fry Shack.
And you also said that Avery's phone was like her third kidney, correct?
Yes, she would never be apart from it for long because, like most
So, can you explain to me how Avery would go a whole day and a whole night and realize that her phone was missing the next day?
She must have been thinking about the incident that happened with Alex Fuentes, but I'm not so sure why she didn't remember about the phone.
And the next morning, you said you tried calling. How come you didn't use Find My iPhone?
Because I had an Android phone and I didn't know that I didn't use that was not on our mind at the time.
So let's circle back. The relationship between Mr. Brachman and the defendant was horrible, and they were always angry at each other.
Yes.
And Avery seemed angry the day before the murder, and very upset at what happened.
Objection asked and answered.
Your Honor, I'm just trying to confirm and better show the witness's response for the jury.
The objection's overruled.
So I repeat my question. Avery seemed angry the day before the murder and very upset.
Yeah, she was very upset the day before Brachman's murder.
And Avery's phone was like her third kidney, and she was never apart from it.
Yes, like most teenagers, they would never be apart from their phone for long.
And you guys weren't at school the day of the murder.
No, we had this because classes were going to be boring and dry, and we had finished our reading finals, and we were going to look for Avery's missing phone.
No further questions, Your Honor.
Any redirect?
Mr. Perkins, were you and Avery together the entire time?
Yes, we were together the whole time.
No more questions, Your Honor.
All right, thank you. The witness may step down. Are there further witnesses for the defense?
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
You may. I know the witness has been previously sworn and likewise advised about the right to testify. You may be seated and you may begin the inquiry when you're ready, counsel.
Can you please introduce yourself to the court?
My name is Avery Becker.
And why are you here today, Miss Becker?
I was wrongfully accused of murdering Mr. Brachman.
And how did you know Mr. Brachman?
Mr. Brachman was my old high school mock trials coach.
And what school did you previously attend?
I was a senior last year at Colorado High School, otherwise known as CHS.
And were you a part of any extracurriculars?
Yeah, I was a part of the mock trial career team there for all 4 years of high school and also the National Honor Society.
And can you tell us about your experience with mock trial?
Mock trial was definitely a fun experience, at least for me. I was on the A team, which is the most difficult team to get on, and I also won Best Attorney Award at regionals, which was definitely fun last year.
And can you tell us about your relationship with Coach Brachman?
Mr. Brachman and I had a rocky relationship, you could say. I never liked how he would make us memorize these scripts and would get so upset if we went off them. But I'm pretty sure that's what got us awards. But that's also what got us into some heated moments sometimes.
Can you explain these heated moments?
Well, one time specifically, Mr. Brachman and I got into this argument, you could say, because I went off script and he demoted me to B team over it.
And what happened after you were demoted?
Well, my friend Taylor ended up quitting the team not too long after, so Mr. Brachman put me back on the A team, but that didn't last too long.
Could you explain what you mean by didn't last too long?
At regionals, like I said, I won Best Attorney Award, but at the practice after, Mr. Brachman completely embarrassed me in front of the whole mock trial team and told me I didn't deserve it. And I was so upset in the moment and did the most stupid, regrettable thing I've ever done, which caused him to kick me off the team overall.
And what happened when you were, or how did you feel when you were kicked off the team?
I felt awful. I was definitely angry and upset at first that my mock trial career was over. I mean, it was my senior year and I never got the chance to even finish the season. But I do understand why I got kicked off.
And what did you do to get removed from the team?
Well, out of anger, I took a marker, which I thought was a dry erase marker at the time, and wrote Worst Attorney Award on his car. But I immediately regretted it and didn't mean to make any damages permanently.
And did you ever get to apologize to Mr. Brachman in person?
I wasn't able to apologize in person. I tried to the day after it happened, but his secretary told me he wasn't available and didn't want to talk to me. So I texted him apologizing instead, and he unfortunately passed away before I was ever able to apologize in person.
And now, can you tell us where you were on March 6th?
I was at the mall with my friend Taylor Perkins.
And why were you at the mall?
We were looking for my phone because it went missing.
So, when was the last time you recall seeing your phone?
The last time I saw my phone was March 5th at the Fry Shack.
And why were you at the Fry Shack on March 5th?
Me and Taylor and some other mock trial members were just hanging out there.
And who do you all remember being at the Fry Shack that day?
Like I said, me and Taylor were there, and we did also see Alex Fuentes there that day.
And how do you know Alex Fuentes?
We were teammates on the mock trial team in high school.
And were you and Alex friends?
Alex would say we're friends, but he didn't really seem to like me.
And you were at the mall trying to locate your phone. What did you do to try to locate your phone?
Well, we were calling my phone using Taylor's phone to try and find it that day.
And what did you do? What would happen when you called your phone?
It would go straight to voicemail, so we assumed it was either stolen or it died.
And did you go to Brachman's house at all the day he was murdered?
No, like I said, I was with Taylor all day, and I don't even know where he lives.
So, in conclusion, did you kill Mr. Brachman?
Absolutely not. I could never do anything like that.
No further questions, Your Honor.
Right, thank you. Cross-examination?
Yes. Hi, Miss Becker. So how were you feeling when you decided to vandalize Brachman's car again? Well, in the moment, I was feeling upset and hurt because he had been my coach for all 4 years of high school, and the fact that I tried to earn this award and I did earn it through my talent, and him telling me I didn't deserve it at all really hurt me, and I expected him to be proud of me in that moment, but he didn't seem to be. Okay, so you vandalized his car out of sadness? Out of sadness, anger, disappointment. Okay. Did Brachman ever give you credit for being good at mock trial? At least not to my face. He always tried, well, on all of us, he would constantly nitpick everything we did. But I do think now looking back, that was his way of caring and kind of trying to push us to be better. Do you feel that the reason you maybe didn't participate as much is because you wanted to kind of get a reaction from him? Absolutely not. I enjoyed mock trial. It was something that was like fun and like a sport to me. And I just didn't necessarily need to put in as much work because it was something that came so easily. Okay. So if you enjoyed mock trial so much, why would you risk it? Why, when you vandalized Brachman's car? Well, I'm a teenager and I make mistakes. And like I said, that was a huge mistake. And I never meant for it to be permanent. It was very out of the moment frustration.
So you didn't think about the consequences of even vandalizing the car with a erasable marker?
I did, but I didn't think it would be as far as being completely removed from the team.
Okay. Did you feel any resentment towards Brachman for constantly putting you down and not giving you the credit you deserve?
Well, in that moment, I definitely did feel a little disappointment and kind of wished he had said he was proud of me or had even tried to show that.
Okay. And if you and Alex Cifuentes, if you guys weren't so close, how come you sat with him and engaged in a conversation at all at the Fry Shack the day before the murder?
Action relevance.
Your Honor, I'm just trying to prove the relationship between the defendant and one of the witnesses.
I agree. I think relevant. I'm persuaded by the argument that there is relevance in terms of the motivations of the actors and the witnesses who have testified. So the court will overrule the objection.
Okay. Do you need me to restate the question, Ms. Becker?
No, that's fine. Well, just because we weren't friends doesn't mean I needed to be rude to him or had to hate him. I'm still a genuinely nice person, so of course I would still talk with him and be a citizen and just be a teammate with him.
Okay. But he did anger you and you ran off to the bathroom, correct?
He did.
Okay. After Mr. Brachman officially kicked you off the team, what did you do again?
Well, like I said, in that moment, I thought I had a dry erase marker in my hand, and I wrote Worst Attorney Award because it was kind of what I was feeling in that moment. And like I said, it was very stupid of me, and I don't understand why I did it looking back, but I did do it.
Okay. I'm sorry. I meant what did you do after the altercation with the car, after you vandalized it?
Well, I went home.
Okay. And is it true that you said, and I quote, "I will get back at him if it is the last thing I do," to your mother?
Like I said, I'm a teenager. I say things I don't mean all the time. It's my mom, and it was out of frustration again, and I was trying to prove my point of I wanted the credit that I deserved.
Okay. And this was directed towards your now deceased mock trial coach, Mackenzie Brachman, right?
It was in that moment, but I immediately regretted it. And even the next day, I tried to apologize to him and own up to my actions and take the consequences that came with it.
Okay. Why exactly did you not tell your mother that you vandalized Brachman's car?
I didn't want her to be disappointed in me, like how Mr. Brachman was.
Okay. Now, can you tell me how you went until the next morning until you realized your phone was missing?
I honestly just wasn't really thinking about it. I was just in the moment that day and didn't even realize it was gone.
So when did you realize the phone was missing?
The morning after I came home from the Fry Shack.
And how come you didn't try and track the phone?
We did. That's why we spent the entire day doing.
Oh, so you used Taylor Perkins' phone to track it, like with a GPS tracker?
No, we tried to track it through calling it and trying to see if it would ring.
And why didn't you just use Find My iPhone?
Well, at the time, we didn't. Well, Taylor has Android, so we didn't think that it would be possible to use Find My iPhone because iPhone is an Apple product.
Okay. So are you now aware that you can use Find My iPhone with an Android?
I am now.
Okay. Can you tell me your exact trail on March 6th?
Well, I was at my house. Taylor came and picked me up. We decided to ditch school. We went to the mall, spent the entire day at the mall, and then we went home.
So you didn't go back to the Fry Shack to look for the phone?
The Fry Shack's at the mall. That was the first place we went.
Okay. Why did you message your former classmate, quote, well, if he's still upset about his car, then he's gonna be really upset when he sees what I do to his car, end quote. And then I'm gonna wait until he's at work, then break in and trash it. That'll show him, end quote.
I didn't send that to Alex. I didn't even have my phone at the time when those texts were sent.
Okay, so you said that Taylor picked you up, correct?
Yeah.
Are you sure you didn't pick him up?
Oh, yes, Taylor did pick me up. My apologies.
Okay, would you say you were more angry or sad about being kicked off the mock trial team?
Well, at the very first couple of minutes, I was majorly angry, and then it became more of sadness that this thing I had put all 4 years of high school into, I couldn't even finish.
Were you angry or sad towards Mr. Brachman?
It was very similar. At first, I was definitely angry, and it definitely turned into more of a sadness and disappointment that I wasn't somebody he could be proud of.
And the last time you physically spoke to Brachman was during the big altercation about his car where he officially kicked you off the team, correct?
That was the last time I talked to him in person, yeah.
So he never responded to any of your apologies?
Well, understandably, he didn't want to talk to me because I did do that to his car and it did cost. I did offer to pay for the damages, but I think it was bigger than that.
And were you angry that he didn't respond at first, or?
Well, I kind of understand why he didn't respond. I wish I was able to talk to him before he did die, but there's nothing I can do about it now.
Okay. No further questions, Your Honor.
And any redirect?
No redirect, Your Honor.
Right.
The defense rests.
Okay, so it appears the evidence has concluded in the case, and we'll proceed then to closing arguments. When you're ready for the people, you may begin closing argument. You may take a moment to set up if you need to.
I have it. Ladies and gentlemen, counsel and the jury, and your honor, there is a lot that we learned today, and we, the prosecution, have proven beyond a shadow of a doubt that indeed Miss Becker is guilty of murder in the first degree. We promised facts and logic, and we delivered. Our expert in cell phone forensic data recovery, who had also had 19 years of homicide experience, has shown us lots of different exhibits. These exhibits help highlight the scene and help give us a description of what the murderer's figure looked like. Detective Markowitz was able to get videos from Mr. Brachman's phone that showed what the Ring cameras captured on the day of the murder. Exhibit 12, which has been entered into evidence, which is also the Ring video, showed us someone with the same figure as Miss Becker. Around the same time of the murder, Miss Becker's phone was receiving messages. These messages were pinged off of a cell tower, and the cell tower shows a clear path from Miss Becker's house to Mr. Brachman's house, as seen in Exhibit 15, which has also been entered into evidence. And again, I remind you, Your Honor, and the jury, that this was around the time of the murder. Alex Fuentes, who I remind you was close to Avery Becker, revealed to us that the hatred between the defendant and the victim was prominent. Miss Becker had already planned to vandalize Brachman's house out of retaliation and rage for getting kicked off the mock trial team. This was seen in Exhibit 14. Ms. Fuentes had shown us screenshots of the text between the two, and Miss Becker said, and I quote, "Well, if he's upset about his car, then he's really going to be upset when he sees what I do to his house." These texts were sent the day before the murder. This didn't have to be a planned murder. It was a planned burglary gone wrong. The defense's argument is presented by an ex-cop who is being paid and has prejudice towards cops. I would also like to remind the members of the jury that Avery's best friend Taylor Perkins testified in court that the victim and the defendant had a rocky relationship. Mr. Perkins also said that Avery was really angry and upset the day before the murder. These two were also not at school the day of the murder, and Mr. Perkins testified that Avery couldn't go one day without his phone. These are facts, and beyond a shadow of a doubt, the defendant, Avery Becker, is indeed guilty of murder in the first degree, as well as burglary in the second degree. We ask that the jury finds in favor of the prosecution. Mackenzie Brachman deserved justice. Thank you.
All right, thank you.
I
And
might just
close.
have a
Sorry.
couple moments to set up.
Yes. Take a moment.
An easy conclusion. Avery Becker is a normal kid who was blamed for a murder of a coach. Today, you have heard from 3 people, Avery Becker's side of the story. You see, the prosecution's case has holes in it. Not only does Avery Becker have an alibi, but the investigation was sloppy. And there was an alternative suspect. Today, Avery Becker has been charged with first-degree murder and second-degree burglary. The prosecution has the burden of proof. They have to prove to you beyond a reasonable doubt that Avery broke into Mr. Brachman's home with the intention to vandalize it and killed Mr. Brachman in the process. But you see, the prosecution has not met their burden. Avery Becker has an alibi. She was at the mall all day the day of the murder with her friend Taylor Perkins. Not only has Avery Becker told you that, but so has Mr. Perkins. So how would it be possible for Avery Becker to commit a crime? She wasn't even there. The prosecution ignored all these simple facts just so they could blame Avery Becker. The easy conclusion. An easy conclusion. The investigation was sloppy. The only reason Avery Becker was a suspect was because Alex Fuentes had sent him screenshots to Ms. Markowitz. But there's no way to prove if these screenshots are real. For all we know, they could be forged. And the police could have avoided this question by doing one simple thing, obtaining Alex Fuentes' phone. But they didn't. Continuing with the sloppy investigation, there is a Ring doorbell video that the investigation was based off of. In this video, there was a suspect covered head to toe with a mask and gloves. There was no way to tell who this person was. You couldn't tell the gender, the race, or even the age of this person. So how did the prosecution know that this was Ms. Becker? They didn't. They relied on the fact that this person was the same height and build. You see, there's many people in this world that are the same height. The biggest hole of all was that they were basing where Avery Becker was based on where her cell phone was. But you have heard today from Mr. Blake Van Owen that a cell phone tracking is not like a GPS. It covers a range of 6 miles. To add on to that, Avery Becker told you she didn't have her phone. The prosecution ignored all these things and blamed Avery Becker. The easy conclusion. There was an alternative suspect, Blair Rollins. Blair Rollins' father, Jonathan Rollins, was sentenced to life in prison by Mr. Brachman. That gives him motive. To add on to that, Blair Rollins was not at school the day of the murder. He is thought to no longer be in the state of Colorado. You see, the defense does not have the burden of proof. But if a part of you believes that Blair Rollins is a suspect, that is reasonable doubt. And the prosecution ignored this and blamed Avery Becker. The easy conclusion. An easy conclusion. Avery, from what you've heard today, Avery Becker has an alibi. She was at the mall all day the day of the murder. The investigation was sloppy and left lots of unanswered questions. And there was an alternative suspect that the police didn't even look into. You see, the prosecution has not met their burden of proof. I now ask you to find Avery Becker not guilty. Thank you.
All right, thank you. Well, it seems like the arguments are completed. My memory serves we don't do rebuttal. Is that just making sure? Or do we?
Your Honor, we do rebuttal.
Oh, you do? Okay, my mistake. I apologize. All right, any rebuttal argument?
Yes, Your Honor.
You may.
Ladies and gentlemen of the jury and Your Honor, the defense claims that the police work was choppy and rushed. However, our experts have testified that they ran a thorough investigation, and might I remind you that they have had years of experience in homicide detective. They were not able to obtain the phone. However, they did see cell phone tower records from Miss Becker's phone itself. And that the record also show that the phone did have a clear path from Miss Becker's house to Mr. Brachman's house, as seen in Exhibit 15. Mr. Perkins has also testified that Miss Becker could not go one day without her phone. And last but not least, all of the witnesses that the defense have presented have a bias towards the prosecution. A disgruntled ex-cop who hates cops in general and is always on defense has every reasonable motive to go against what is facts and logic. And Taylor Perkins and the defendant have every reason to lie. That will be all. Thank you for your time.
All right, thank you. We will submit the case to the jury and instruct them and let you know when we hear a verdict. It appears the case is submitted at this time.